Good afternoon. I am Jennifer Butchart, Associate Director of Plan Giving at University Hospitals Kingston Foundation. Welcome to UHKF's first webinar in a series on value-based estate planning. Before we get started, there are a few things I'd like to mention. First of all, Alexandra is having a few camera issues, so you'll not be able to see her during the presentation, but you will be able to see her slides. Today's webinar is being recorded, and the presentation will last approximately 35 to 40 minutes. There will be time to answer your questions, and you can ask a question anytime during the webinar using the Q&A feature at the bottom of your screen. It is now my pleasure to introduce Alexandra Manthorpe, partner in Wills and Estates at Cunningham, Swan, Carty, Little, and Bonham. Alexandra enjoys working with clients to help them prepare for the future so that they can protect themselves and provide for their loved ones in the best manner possible. Welcome, Alexandra. I will turn it over to you.
Thank you so much, Jennifer. And I'd like to say a huge thank you to UHKF for inviting me here today. And thank you to everyone who's joining. As Jennifer mentioned, I am unfortunately having some camera issues. So hopefully you can hear me and hear my presentation, but I'm not appearing on camera right now. However, I do have some slides to share. So hopefully those slides will be beneficial. As Jennifer mentioned, we do want to leave a lot of time for questions. Just because we're doing this online rather than in person, we will be doing questions at the end. So if I do raise anything, you can certainly send in your question earlier while you think of it, while it's fresh, but I will be addressing it after my presentation just to kind of keep things moving. So the intention is I'll do my presentation, we'll leave lots of time at the end for questions. So I hope that this is beneficial for you. I do need to do my kind of usual lawyer caveat that this information is intended as information only. It's not legal advice. Part of what makes my job so interesting is I never really know who's going to walk through the door and what their situation is going to be. So there really is kind of no cookie cutter estate plan that we can give to everyone. Everyone's situation is different, which means we give different estate planning advice to everyone. So it is really important to speak with a lawyer about your particular situation and to come up with an estate plan that does make sense for you. So value-based giving, I mean, I think this is so important. It is really important to do wills and powers of attorney and revisit your estate plan generally, just to avoid leaving a mess. You know, I think that's something that's important for all of us. We've all heard horror stories of estate administrations that have gone awry, either because maybe the person didn't have a will or they had an outdated will and they hadn't updated it to provide for their current situation. So I think a key goal of today and what I want to leave you with is some information to help avoid that. So how can we avoid leaving a mess for your friends, for your family, for your loved ones to ensure that your wishes are actually fulfilled when you do pass away? So what I wanted to start with, I'm going to kind of give, 10 top 10 tips that I give to people when they're doing estate planning generally. But what I thought I would start with are important considerations to do when you are starting this process. So I think I'm probably preaching to the choir here when I say that everyone should have a will and powers of attorney. So I do commend you for doing estate planning. Again, it should make life easier for you and your family. But it is a process, right? It's not just, you walk into the lawyer and they hand you a will. It really is something that you kind of need to prepare for and work on. So this slide here, and we'll go over it together, is really things to consider when you're just starting the process. And in fact, these are things you should probably consider before you meet with your lawyer. These are things that I go over with all of my clients. I'm going to ask you about your assets and liabilities. I'm going to ask you about your potential beneficiaries. Who are your other advisors? Who are your intended executors, attorneys? So it's really important. The more that you can do to consider these things before you meet with the lawyer, it may actually save you money. Because lawyers, as you probably know, we bill on time. We don't, some lawyers do. We sometimes have set fees for certain matters. But to be frank, usually the more complicated a client is, the more time that is required to work on their file, the more expensive the legal invoice will be. So the more that you can do to kind of prepare for your initial meeting with your lawyer, get this information, collect it, think about it, the easier it should be when you actually meet with that lawyer, and the more efficient it should be when it comes to drafting your wills and powers of attorney. So the first item I encourage all people to think about before they actually even meet with their lawyer, and in fact, your lawyer might ask you for certain of these things, is gather information and documentation about all of your assets and liabilities. So for example, maybe you can collect or print out some recent bank and investment statements, pension statements, life insurance statements. We are going to ask you about, for example, how you owned your home. Now, if you bought your home 20, 30, 40 years ago, you don't have that information anymore, that's fine, but just be aware that it is something that the lawyer's going to raise with you. We want to know, do husband and wife co-own their home as joint tenants? Do they co-own it as tenants in common? Is the home actually just in one person's name? So it is really important to kind of print out these things, and ideally you can bring them with you. And I actually, I'll be very frank, I do estate administration as well. And if you haven't recently gathered information about your bank, bank statements, investment statements, pension, life insurance. This is really important when someone passes away. So I find a lot of clients find that it's a really good exercise. Of course, we all know what we have. You ask anyone on the street, I can stop Joe Blow and say, hey, what do you have? And he'll say, oh, I got 2 accounts at Scotiabank. I got, 3 at RBC. They can list it off. But that's very different from what your executor knows. So your executor, especially if it's a friend or a more distant family member, they may not know what you have. So the more you can do to gather information about all of your assets and liabilities, the better it is. I have had estates where we have absolutely missed assets. We know it. Mom mentioned a life insurance policy. We can't find anything in our personal papers about the life insurance policy. Maybe we write to the big life insurance companies, but if it's with a smaller life insurance company, we may miss it. And that's obviously unfortunate. I don't think anyone would want for potential assets to go unclaimed by their beneficiaries. So again, the more you can do to gather information and documentation about what you have, what you owe, the better it is. Also, in addition to that, is gather information about all potential beneficiaries under your will. Now, a lot of you are thinking, well, I'm going to leave it to my spouse, and then if my spouse is deceased, I'll leave it equally to my children. That's all well and good. But for example, most of us include clauses that, heaven forbid, if one of our children predeceases us, that it goes down to grandchildren as well, that child's children, the deceased child's children. So it's important to know not only who is currently in your will, maybe who are the primary beneficiaries do you expect to receive something, but if you are including, say, friends or more distant family members, grandchildren, nieces, nephews, brothers, sisters under the will, even just as potential beneficiaries, it's really important to have current contact information. I'll just add as an aside, but a very important aside, we really, really like to know if anyone is outside of Canada as well. So if any of your children are in the US or foreign countries, it can be obviously extremely difficult. It's difficult to find Canadians after death. It is even more difficult to find people who live outside of Canada after death. So again, the more you can do to print out full legal names, and again, noting that sometimes when people marry, they change their names, current mailing addresses, telephone numbers, and of course, nowadays, maybe even more importantly, is email addresses, because obviously young people might move a lot, they might change, work somewhere else after university. So it is really important to kind of, again, gather this information as well. We do have quite a large spot on our firm's intake form for contact information for beneficiaries. But again, this is really important when it comes to estate administration as well. Your executors are going to know how to contact people. So the more you can do to gather that information, because again, you are the keeper of the knowledge. You know how to contact everyone, but your executor may not be related to these people, may not even know these people. So again, don't create a big task for your executor. Try and keep an up-to-date list of how to contact people. The next one that it kind of flows to, pretty much makes sense, is a list of your current financial institutions and also your advisors. Typically, when someone does pass, unless there's a pressing reason to change things, we're often using the financial advisor or the investment advisor that you may have used during your lifetime, potentially to at least manage funds for a period of time after you die, and potentially also for any trusts that are created. Typically, again, if you're working with an accountant before you die, your executor might be retaining that same accountant to do your terminal tax return and to do any estate returns. So it is really important for your executors to know, first off, where is your will and powers of attorney? So lawyers' contact information is really, really important. But also, again, who are your current professionals? Because your executor generally will have to reach out to these people pretty quickly after you die just to ascertain what you have, where it is. And obviously, if these professionals may be needed to help your executor as well in the estate information. I don't think it should surprise anyone, but you never know. You cannot force someone to be your executor. So you can name someone as executor under your will. You can name someone as guardian for your children. You can name someone as your attorney for personal care or attorney for property under your power of attorney documents, but you can't force them to act. So it may sound kind of obvious, but I'm often surprised that a lot of clients haven't actually asked their brother if he's willing to be the executor. They haven't actually asked their friend if he's willing to be their attorney for property. So before you actually name anyone in your will, whether it's for the estate trustee executor position, whether it's for guardian for your children, if you have any minor children, or to act as your attorneys, it's really important you speak with them and confirm their willingness to act. If someone tells you no, they say, oh my gosh, I totally would, but I know I'm already being asked to do this for 5 other people, don't be offended, because if you haven't yet signed your wills and powers of attorney, you can still change them. So generally, we want to know if someone is unwilling or unable to act before it comes to that time, right? So it's important to speak with people, confirm if they're willing and able to do it. And if they say no, again, don't be offended, move on to the next person in your list and see if they're willing and able to do it. If you're really stuck, and this is a common concern for people, is I don't know who to name as my executor. I don't know who to name as my guardian. I don't know who to name as my attorney. That's absolutely fine. And that's a discussion that you should have with your lawyer. So I have a lot of clients, again, they've gathered all the information about their assets and liabilities. They know who they want to give the funds to, but they just don't know who they want to do it for them. And that's fine. So again, at least turn your mind to this before the initial meeting with your lawyer, because again, your lawyer's going to ask, but it can be a discussion, and it can be actually quite a fun and interesting discussion. Sometimes I do send clients home with a bit of homework to kind of consider their various options, but it is important you kind of consider it at very least before you're meeting with the lawyer. And lastly, and this is so important, is what do you value and what do you want your legacy to be? So I do not tell clients what to do. I do not tell clients, leave it equally to your children, leave it to charity. I think at the end of the day, this is your will. This should be what you want to do with your property. So certainly I think the lawyer is there, and the benefit of working with the lawyers, we will make you aware of your obligations. And that's maybe the downside of kind of doing a do-it-yourself will or a will kit, is we will kind of review, what liabilities you have, what potential liabilities you have to people we call, financial dependents. So for example, if you do have, a spousal support obligation, if you do have a child support obligation, making sure that those obligations are fulfilled. That's the benefit of working with a lawyer. But at the end of the day, whatever you have after your debts and taxes are paid in full, that's really for you to consider, and there can be great value in giving to charity. There can be great value in helping family members and friends. So I think a good lawyer isn't going to kind of say, oh, well, you have to do this. I think it's really for you to say, I'd like to do this, and then work with the lawyer to kind of enact that in the best manner possible. So again, what do you value? What would you like your legacy to be? And I will actually say it is quite common to include charities. Sometimes people include maybe a little cash amount to charity and then the balance to their children. Sometimes charities are included as what we call a common accident beneficiary. So if something happens to all of us, if something happens to my spouse and my children, then I'd like for it to go to charity at that point. But just consider these things. So again, the more that you're able to turn your mind to what do you value, what do you want your legacy to be, then the more productive the meeting with your lawyer is going to be, right? Because at the end of the day, you've got to tell us, who's this going to, right? So the more you can do to consider that before you go in, certainly the more efficient and hopefully maybe at the end of the day, a little less expensive, the meeting with your lawyer should be. So what I'll go through next, if it's okay, is kind of some 10 estate planning considerations. So I know kind of the title of the program was about things to consider when making your will. one thing that I always love to draw people's attention to are powers of attorney. So powerful powers of attorney. So for almost all of my clients, I'm not only doing a will, but I'm doing powers of attorney as well. So powers of attorney are documents which allow another person or persons to make decisions for you on your behalf during your lifetime. So these are particularly important, as you might expect, in case you suffer a medical emergency like a stroke, or if you lose mental capacity. So for example, if you develop some sort of cognitive impairment, perhaps Alzheimer's or another form of dementia. In Ontario, we have two types of powers of attorney. So a power of attorney for personal care and a continuing power of attorney for property. I will just say briefly about powers of attorney is that the legislation relating to powers of attorney was drastically overhauled in the 1990s. So in 1992, we had the Substitute Decisions Act, and in 1996, we had the Healthcare Consent Act. So if you haven't revisited your will and powers of attorney in quite some time, maybe since the early 90s, I would really, really encourage you to revisit your powers of attorney in particular. Before those two important pieces of legislation, it was quite common to have what we used to call a general power of attorney, and it was actually one document that purported or did actually cover both property and personal care. Like I said, now it is actually two separate documents. So you can name the same people. You can name the exact same people to make property decisions for you and to make personal care decisions for you, but it should be two separate documents. What happens if you don't have powers of attorney? So if you do not have powers of attorney in place and you become mentally incapable, a person, usually a spouse or a family member, may need to apply for something called guardianship. Guardianship is not desirable, to say the least. So it usually does involve going to court, and it can cost thousands of dollars. Please remember that powers of attorney are while you're alive. So if you don't have powers of attorney and you become incapable, there may be a brief period of time where no one has authority to manage your property for you. And if you've got ongoing obligations, that can be, of course, a little bit scary. So usually guardianship is a crisis situation. Someone has had a sudden medical impairment, stroke, heart attack, car accident, and someone is realizing, uh-oh, mom didn't have a POA. What do we do now? I just want to reiterate, because again, I know our focus is wills today, but no one, not even a spouse, has an automatic authority to manage your property on your behalf. So just let me repeat that. Just because you co-own an asset, you may co-own a bank account with your spouse, you may co-own a home with your spouse does not have an automatic right to deal with your interests in those assets. So again, if a husband becomes incapable, the wife does not necessarily have an automatic right to sell that husband's 50% in the home. So again, people think, oh, I can just co-own everything, that avoids the problem. No, co-ownership does not get rid of the need to create powers of attorney. So again, if you co-own assets, your spouse does not have an automatic right to deal with your interests in that asset. And of course, they don't necessarily have the right to file taxes for you and do other important things for you. Because we are talking, obviously, it's UHKF, your power of attorney for property can address gifting. So there are actually provisions under the Substitute Decisions Act about gifting to charities. So what I usually say to clients, especially clients who are in the habit of gifting to charities regularly, maybe they're giving the tithing or expenditures to their church, maybe they're regularly gifting to another charity, is do actually mention this, and we can include a provision right in your power of attorney for property about gifting to charities, maybe even gifting to family members. So it is, if you're in the habit of kind of gifting regularly to charities or to others, discuss this with your lawyer, because it is something that can be included right in your POA documents. So again, please don't forget your POAs when you're doing a good estate plan. Make a will. It is actually Make a Will Month. So I'm very grateful to Jennifer for inviting me here today, because November is officially the Ontario Bar Association's Make a Will Month. So I'm probably preaching to the choir. It's really important to have a will. Jennifer, I think, has heard the story before, but I was doing a seminar 8 or 9 years ago, and a gentleman came up to me afterwards and he said, Alexandra, if I make a will, I'm going to die. And I looked at him and I said, you're going to die. Make a will. Like, you're not magically preventing your death by not having a will in place, right? So I know in a lot of, and we ended up laughing about it. It was kind of funny. I know obviously in a lot of cultures, there's a stigma about making a will, but I just want to assure you, there is no bad luck. There's no bad luck. There's no empirical link between seeing me and then having something happen to you. In fact, most of my clients feel better after doing their wills again. So it really is important to get over that stigma or that mental roadblock. There's no bad luck. Doing your will is really, really important, because I do deal with intestacies, which is when someone dies without a will, and it'll be our next slide, and they're a mess, right? So the other major drawback, of course, if there's no will, is no executor. So because the will, one of the key important things about a will is that it does name an executor. It names a person to have immediate authority to start to make inquiries about your assets, to start to make inquiries about your debts, to deal with the funeral home, to do all those kind of very, very important immediate post-death actions. So if you don't have a will, no one is automatically empowered to do that. Again, not even a spouse is automatically empowered to do those things. So even if probate is required, ultimately maybe to sell your home, to deal with certain of your assets, at least if there's a will, the named executor can make inquiries, and the bank will at least speak to the named executor. Again, one real problem is when there's no will, no executor, the banks surprisingly, don't want to release information about your assets and liabilities to someone. So this can be a real problem. So again, make a will. It's just really a huge thing. You won't benefit from it, obviously, but your friends and your family members will. So what if I don't have a will? So what if I do pass away without a will? It is the rules of intestacy. So the rules of intestacy are quite old. I'm not being facetious. I really don't think there's been much of an update in the last 100 or 200 years. And they exclude common law spouses, friends, charities, and non-blood relatives, so stepchildren. So I will say, quite frankly, I don't think the rules of intestacy have kept up with modern Canada. It hasn't really kept up with the fact that people aren't always getting married. They're living in common law relationships. It hasn't really kept up with the fact that there's a lot of blended families now. So unfortunately, under intestacy, we see a lot of unfairness. We do see a long-time common law spouse excluded. We do see stepchildren who were just as loved and just, probably the deceased would have wanted to benefit maybe as much as children, being excluded. So I think it's very important, again, to do a will, because under your will, you have a lot of control. You can include stepchildren. You can include common law spouses. Again, intestacy is not fun. Quite often what we have to do is we get a horrible situation where someone's lost their long-term common law partner of 20, 25 years, and they're having to sue their estate to kind of have the right to stay in the home. To have, and you're thinking like, gosh, this isn't what, John would have wanted. This isn't what Mary would have wanted. No, it's probably not. So again, don't let the government in their legislation dictate who gets your assets. It is really important to do a will, especially if there are people you'd specifically like included. And also, I'll say on the flip side of that, if there are people you would especially like excluded. May not surprise you, but sadly, I do sometimes have clients who do wish to exclude certain of their children or certain of their more distant family members. Perhaps they're estranged from their brother. They're okay with their sister getting property, but they really don't want their brother to get anything. Again, if you make a will, you can exclude your brother. You can exclude even adult children in certain circumstances. So again, really important to discuss that with your lawyer. If there are people you would especially like to include, again, people maybe other than children and married spouse, and also if there's people you'd like to exclude. I think it is really important, because it's UHKF, just to talk about charities, charitable giving. A lot of people make pledges to charities, which again are wonderful things. I'm sure Jennifer will tell you it's great to have a pledge, especially when it comes to kind of budgeting and knowing what gifts you might receive in the next, fiscal term. But pledges to charities aren't always binding on death. So there is actually a decision on this, and it is, as you can see, from 2003. So it's about 20 years old, but it's still considered a pretty leading decision on pledges. It was the Brantford General Hospital Foundation and the Marquis Estate. And I'll just read the fact scenario to you. Helmy Marquis was a generous philanthropist, in particular to the Brantford General Hospital. She was approached by the hospital CEO as a potential lead donor for a community campaign. In November 1998, she signed a pledge in which she promised to donate $1 million over 5 years. Awesome. Everyone's happy. We're getting $1 million. In April 2002, she made her first initial payment of $200,000. Then, unfortunately, the following month, May 2000, she died. What happens? Well, thankfully, Mrs. Marquis did have a will, and the Brantford Hospital General Hospital Foundation received a gift of 1/5 share of the residue. So the residue is whatever is left after debts and taxes, after any specific gifts. For example, my car to my son, that would be a specific gift, and after any cash gifts, $1,000 to my granddaughter. So whatever is left after debts and taxes, after specific gifts, after cash legacies, 1/5 of that was to go to the hospital foundation. However, her executors refused to pay the balance of $800,000 owing on the pledge. Unfortunately, the parties kind of couldn't come to some sort of agreement, so it went to litigation. The end result was that the judge held that for the pledge to be a contract, there must be consideration for the promise of a payment. So consideration is really important at law. Law likes bargains. So for example, I'll give you $5 and you give me 5 apples. So we like I'll give you something of benefit. You give me something of benefit. They don't need to be the same thing. They don't need to be of equal value. But as long as I'm getting something, you're getting something, we may have a binding contract. So that's called consideration at law. So even though the hospital had named a unit after Mrs. Marquis and her late husband, that didn't constitute consideration or a benefit sufficient enough to make the pledge binding as a promise that would apply above and beyond the gift to the foundation under the will. So the hospital's arguments to enforce the pledge based on part performance or estoppel, the fact that she'd made part of this pledge, it failed. And the plaintiffs failed to establish that they act in reliance on the promise of Mrs. Marquis. So I really include this, obviously not to embarrass the hospital foundation. I think it was, I think we can say the reason I'm including this, it was an unfortunate situation. And of course, because Mrs. Marquis was deceased, we don't know what she would have wanted. Did she want to give the hospital foundation 1/5 plus the 800? Did she intend for the 1/5 to cover the 800? We don't know, right? So I think if you are planning to give a particular amount to a charity, I always include it in the will. So I have done this for numerous clients, and we can word it as a conditional gift. And it says basically, hey, as of today's date, I've pledged, 10,000 to the UHKF or some other charity. If on the date of my death I haven't fulfilled this pledge, please pay it ahead of any other gifts. So you can make conditional gifts that do deal with pledges. So again, I think if you've made a pledge, it's really important to be proactive and tell your lawyer about it. A lot of clients say, oh, but that'll be done next year. I don't need to include it in my will. That'll be done next year. I don't know about you, but most of us don't have a calendar with our date of death in it. Not trying to be facetious there, but we don't know when we're going to pass, right? So again, I encourage clients, I'm like, I know you're intending to make this pledge next year. Why don't we just put it in your will for now? We'll make it as conditional. And then you know what, if when you pass in 10, 15, 20 years, even longer, and it's fulfilled, it doesn't apply, right? But at least we've got it in there for now for this period of time when the pledge is unfulfilled. So not only is it important to have a will, it's really important to have a current will in place. What happens when your relationship changes? So we used to have a provision that legal marriage automatically revoked a will. This was the law. This was the law in Ontario until January 1st, 2022. And this used to shock clients. They'd say, I have a will and then I got married. And I'd stop by and say, you don't have a will. They say, yeah. No, I've got a will and then I got married. I say, no, you don't have a will. So that is actually no longer the case. So gratefully. I do want to point out, however, if you did make a will prior to January 1st, 2022, and you became legally married before that date, your will may, and I have to say may, have been revoked. There is something called a will made in contemplation of marriage, and that used to kind of survive this archaic rule. But otherwise, we did have a lot of accidental revocation. And again, what happens when you don't make a will? It's intestacy. So thankfully, legally married spouses are included under intestacy, but it may not be the division between your new spouse and maybe your children or whatever that you would have wanted. So legal marriage does not automatically revoke a will, but obviously if you do get married, if you enter into a common law relationship with someone, it is extremely important to update your will and your POAs to take that into account. Now, conversely, separation or divorce, it doesn't automatically. So there are some rules under which a former spouse can eventually be excluded by operation of law. So eventually, if you are, separated or divorced long enough, your former spouse can, especially if you get legally divorced, not just separated, but legal divorce, they can eventually kind of, I'll say, be kicked out of your documents. But during that period of time where you're in limbo, and unfortunately, maybe if any of you have had a relationship breakdown, what I'm talking about, there is that period of time where things aren't settled, right? And gee, what am I going to end up owing to him or her? What is he or her going to end up owing to me? You're in that limbo state, right? So whenever a significant relationship begins or ends, it's really important to update a lawyer, talk to a lawyer about updating your will and your POAs. Again, even maybe just to remove your soon-to-be ex-spouse, even if you haven't formalized things. So again, maybe work in connection with your family lawyer and your estate planning lawyer to do that. What about minors? So minors are people under 18 in Ontario, and I think most of us know this, but minors can't receive property. So you can't just leave funds to an individual under 18 and hope they get it. It is a problem. There is a governmental agency called the Office of the Children's Lawyer, and they typically deal with property rights of minor beneficiaries. But it is important to include a trust. So again, one of the main benefits of doing a will is that you can include a trust and you can give it to young people at a later age. And it doesn't need to be 18. It can be 25, it can be 30. I don't know about you, but I wasn't particularly wise with money at 18. So thankfully I didn't end up getting any inheritances at that age anyway. But it is really important, for example, if you've got children, if you've got grandchildren, maybe include a later age, maybe make it so that they get their money at 25, they get their money at 30. Now, a lot of people say to me, but what if they need money before then? A well-drafted trust allows the trustees of that trust, so the people who are managing the trust funds for your children, your grandchildren, your nieces and nephews, whoever you're including, to access those funds before that age. So again, if your kids do need money for post-secondary education, if they need money for anything else, maybe some positive travel that the trustee knows you would have approved, generally we give the trustees discretion to access funds before age 25 or 30, but that's the age at which it gets turned over to the child, grandchild, whoever it is. I'll just speak to this briefly, but it is obviously a very important consideration for parents, and I have minor children myself, but who would you like to have custody of your children? It is important to note that whoever you name will need to go to court. So at the end of the day, the court does reserve the ability to approve or disapprove who you have named in your will to have custody of your children. Now, that said, a court will usually approve the person named by the custodial parents. So again, a very important consideration is who do you basically would like to step into the parenting role and act as decision maker for your children until they're 18. That particular right, the right to act as guardian custodian, generally ceases once the child is 18. Beneficiary designation. So again, I know we're talking about wills, but a lot of people have extremely valuable assets in registered accounts. And by registered accounts, I mean RRSPs, RIF, I mean tax-free savings accounts, those kind of vehicles. A lot of people also have significant funds in life insurance policies. And of course, some people have pensions. So one cool thing about registered accounts, RSPs, RIFs, TFSAs, life insurance policies, pensions, is you can designate a person or persons, or even a charity sometimes, as beneficiary. So the one that is most restricted is pensions. So generally, for most pensions, if you have a spouse, there's kind of a particular formula about your spouse getting your pension. But for the other assets, for life insurance policies, TFSAs, RSPs, RIFs, you generally have a lot more freedom. Now, there can be tax implications, or I'll say tax pros and cons about who you name as beneficiaries on these assets, but it can be a good and unique way to get funds to people immediately. The benefit of a beneficiary designation is that this asset can pass outside of your estate for probate tax purposes. So again, if you do designate someone to receive your TFSA, the whole value of your TFSA can go right to that designated beneficiary. It doesn't become part of your estate for probate tax purposes, and it gets paid out to that person right away. So when you are meeting with your lawyer, again, your lawyer, and I review this with clients, is I say, who have you named on your RRSP? Who have you named on your RIF? And a lot of people don't know. I find in particular, a lot of people haven't named anyone on their TFSA. It is important to remember that in a lot of instances, if you haven't named anyone, the default is estate. which means there's probate tax and other implications. So even if you're legally married, it's really, really important to go to your financial institution, go to your HR advisor, go to your life insurance company, and check who you've designated. Because again, especially if you got an asset maybe before marriage, you may not have updated that to put your spouse. So check that. Please remember, beneficiary designations aren't possible for all assets. So you cannot generally designate a beneficiary on a simple checking account or a savings account. Joint ownership. I'll speak about this just because it's important. I do want to leave time for questions as well. But a very common way for people, especially couples, to try to reduce probate tax is to own assets jointly with the right of survivorship. So for example, it's very common, and I can speak from personal experience. My husband and I, we co-own our home as joint tenants. So he passes away, I get the house. I pass away, he gets the house automatically. Now, joint ownership is not appropriate in all situations. And I would say this especially arises if someone is single, and perhaps maybe even particularly for widows, for widowers. I have a lot of situations where maybe their spouse passes away and they immediately want to add their children to everything. They want to put their kids on the home. They want to put the kids on the bank account. They want to put their kids on the investment accounts. And I said, whoa, hold on. We need to make sure that's appropriate. So again, it's not appropriate in all situations. And you need to make sure you're not accidentally creating problems by adding someone. So problems that we have seen arise is if you add someone, is that a disposition for tax purposes? So have you suddenly created an income tax bill because you have essentially given away part of your ownership of an asset? Is the person you're adding, do they have creditors? So for example, I had a situation very unfortunate that a mother did add a daughter to certain assets. That daughter subsequently went into insolvency. And it was a very scary time because the daughter's creditors were calling mom and trying to take mom's bank accounts. So again, you got to make sure that you're not creating any creditor issues. Same thing. Let's say you add a child and your child subsequently gets divorced. I think the last thing we want is, an in-law suddenly making a claim against your house. So the joke, I mean, we joke, again, I'm not trying to be facetious, but an in-law can become an outlaw. So just again, be very careful about when you're considering things with, not just your son, but your daughter-in-law, son-in-law, other in-laws. And again, if you add someone, what if that person empties out the bank account? What if that person takes out a mortgage against the property? So again, just make sure before you kind of just throw people on a bank account, on a home, on a cottage, really please discuss things with your lawyer and your accountant. I'm just going to speak to this briefly because I think I want to flag it for you to maybe raise with your own lawyer. But probate is very slow at the moment. So again, if people die and they own certain assets, and it depends on kind of the value of the assets, how they own them, what kind of assets they are. That could be an hour-long presentation by itself, what is probate. But generally, if someone dies and their executor needs probate, in order to collect and deal with certain assets like a home, like bank accounts. Right now, it's taking the Kingston court over 7 months to issue probate, to issue a certificate of appointment. I'm actually maybe even closer to 8 months now that I do this. So what that means, unfortunately, is say if mom passes away, it may take 7, 8, 9 months to be in a position to sell her home. That may mean we're having to pay carrying costs. We're having to pay property taxes. We're having to pay utilities. We're having to ensure that the property doesn't become vacant during that period of time. Some courts are even slower. Toronto, so if a person resided in Toronto, right now it's taking about a year to get probate. So it is, and again, that's from when it's filed with the court, and it usually takes at least a couple of weeks to gather the information needed to apply. So if you have one will that covers all of your assets, it's important to note that even if your executor doesn't need probate to deal with certain assets, for example, they don't need probate to deal with your car or your jewelry, or maybe even your home in certain instances, then your executor may nonetheless still have to declare and pay probate tax on those assets. So this is just a highlight, and if anyone would like to receive this PowerPoint, I'm certainly happy to share it. But some main assets for which probate's generally not required: shares in any privately held corporations. So if there's any doctors listening to this presentation, if you have an MPC, a medicine professional corporation, your executors may not need probate to deal with that MPC, even if it's an MPC. And again, that's a discussion, but even professional corporations, there are ways to get it to become a regular, unrestricted corporation for your executors to be able to deal with it. So if you have an MPC, if you have a privately held company, maybe it's a family business, really important to consider doing 2 wills. So again, a will for your assets which require probate, a will for your assets which don't require probate. The other thing I want to flag is that if you do live in the Kingston area and you've owned your home or cottage for 20 plus years, your executor may not actually need probate to deal with your home either. So very important to have your lawyer check title and see if it qualifies for something called a first dealing since conversion. I've had clients with extremely valuable jewelry, artwork, other assets. I'm often doing a secondary will for them. Unsecured loans, interest and trust and estates. So again, one thing that we can do when clients have valuable non-probate assets is we do 2 wills. So I know it's a bit of a mind bend, but basically we create 1 will for their assets which require probate, and that will goes to court and we pay probate tax on it. But then we have a second will for those non-probate assets. It doesn't go to court. We don't pay probate tax on it. Now, having 2 wills really has no income tax consequences. So the CRA has said that a person has only 1 will for income tax purposes. It is purely to minimize probate tax because unfortunately in Ontario, we have the highest probate tax in Canada. So if we're talking about, say, a home worth $1 million and we don't need probate on it, do a secondary will, it can currently save us about 15,000 in funds payable to the Ontario government. So definitely something worth exploring with your lawyer, especially if you have any of those assets on this slide here. What I'll leave you with is just the importance of keeping things current. Obviously your situation is going to change. So the will and POA that you have when you're in your 20s and single, not the same one that you need when you're in your 40s and maybe you have young children or you're married, or when you're in your 70s and retired. So again, if people pass away, significant relationships begin or end, new family members are born, people become disabled, your obligations change. Again, review your will, review your POAs, make sure that they make sense for your current situation. One thing I'm particularly passionate about is planning for disabled beneficiaries. So if anyone whom you're intending to benefit has a disability, and in particular, if that person is on or receiving or may receive payments from the Ontario Disability Support Program, ODSP, it's really, really important to speak with your lawyer about including a fully discretionary trust, or sometimes called a Henson trust for that individual. So that's definitely a takeaway I'd like for you to consider, is that if anyone who you're intending to benefit as a disability, please raise that with your lawyer and make sure that the appropriate plan is in place, because dealing with this after death is very difficult, very challenging, and our options are currently pretty limited. So one bonus I just wanted to leave you with is how essential it is to pick the right executor and the right attorney. So your executor, and you've seen the word estate trustee in here. That's really just the new word for executor. Estate trustee, executor, same thing. Your executor is a great deal of power when it comes to administering your estate. Your attorney has a great deal of power when it comes to making decisions during your lifetime. So picking the right person or persons for these positions is really important. If you don't have anyone appropriate in your family, again, talk to your lawyer and maybe consider the use of trusted friends or professionals. Maybe your lawyer might be willing to do this for you. Maybe you could explore a trust company. So there's always options. So again, I encourage clients to think about this in advance, but if you've thought about it and you really don't know who to name, again, talk with your lawyer, because part of our job is walking through this with clients and helping them identify people who may be the best choice. And it's not necessarily your children, right? It may not necessarily be your spouse. So I think it is really important to be able to talk to a lawyer in a private and confidential manner to make sure that you're picking the people for you. The last thing I'll leave you with, because this comes up so frequently, is if your intended executor or attorney lives outside of Canada, even if he or she is a Canadian citizen, you have to mention this to your lawyer, because there could be tax and other consequences. So not surprisingly, I have a lot of clients with their children live in the US. They want to name them as executor. Maybe you name them as beneficiary, but you got to think long and hard before you name them as executor, because there can be tax and other issues that arise. So again, if any of your intended beneficiaries or executors, attorneys live outside of Canada, please raise that with your lawyer. It's an important consideration. So I know I've thrown a lot at you. I will open it up to questions, and I can stay on a bit later if needed. I've got my contact information here. Unfortunately, that's going to be my screen while I answer questions. But Jen, I'll turn it back to you if we've had any questions come in. I'm happy to answer those.
Yes, thank you, Alexandra. We did have a few questions, and if anybody else has any additional questions, please feel free to put them in the Q&A. So going back to the start of your presentation about collecting items to ensure that they're together, like bank statements and things, there was a question about putting all of this information in one spot and the potential for somebody being able to take all of this information. And they're asking, what is the best way to safeguard this information once it's collected?
Um, it's tricky, right? So what a lot of clients do actually, they find it really helpful. So we give clients a questionnaire. So before clients even meet with us, we send out a questionnaire. Clients fill it out. They bring it to the initial meeting. And I've actually had a lot of clients say, you know what, this was really useful. I'm actually going to make a photocopy of this and keep it with my personal papers so that my executor can access it when I die. Again, it is important to keep this information. I hate to give kind of outdated advice, but keep it in a really secure location. I personally don't really love safety deposit boxes because safety deposit boxes, unless someone is added as a co-owner on the safety deposit box, is typically the bank may not let that person access the safety deposit box. So a lot of people tell me, oh, my will, yeah, I've got a will, it's in my safety deposit box. I've got a POA, it's in the safety deposit box. And I kind of say to them, that's a bit like locking the keys in there with those documents, because again, unless I can show the bank, hey, I'm John Smith's attorney for property, and how do I show them? But by showing them the POA for property. So if I can't actually show the bank, hey, I'm the executor, hey, I'm the attorney for property, and the documents in the safety deposit, they may not let me in. So they're having some catch-22 situations where clients have left important documents in a safety deposit box. Eventually we do get access, but I can tell you the bank managers in there, it's like you're robbing the place. It's a bit funny, but it is quite difficult to get documentation from a safety deposit box. So if you are going to put important information, your assets and liabilities, maybe even jewelry and other, I'm talking actual assets, if you're going to put it in a safety deposit box, you may wish to consider adding your executor as a owner on the safety deposit box so that they can access it if and when appropriate. Otherwise, a lot of people have safes. There are actually those little fireproof boxes that you can buy from certain stores, Staples and other places, little fireproof boxes that people keep this in. So if you do have a safe, again, if you do have some sort of facility or safe facility to put this at home, again, just tell your executor, tell your attorney where the code is, right? The same thing, I know it wasn't asked, but a lot of people ask about, well, what about my digital assets? How is my executor able to access my email account, access my social media, access my iPad, access my iPhone? Again, I hate to suggest this because it's stupid, but like especially if you're not tech savvy, you may want to actually write down passwords. And again, keep that in a super secure location. So keep that somewhere in your home that you know where it is. Maybe again, if you've got a spouse or if you've got children you trust, tell your spouse and tell your children where that is and say, look, anything happens to me, here's how to access all these things. I did have a situation very recently where husband and wife, he'd bought a new, I think it was an iPad, it was a tablet, I think. He bought a new tablet and passed away very shortly after buying it, and the wife didn't know the code. And she was having a dickens of a time. Her son was trying to help her call Apple to get it. It was like months and months, and she couldn't access this brand new tablet just sitting there because she didn't know the password. So the reality is there's not a lot of power to executors, to attorneys to access digital assets. So I hate to suggest something like write it down and put it in a secure place. That might work. For those of you who are more tech savvy, there are a lot of good programs now, like the OnePass and other password protection programs where you can actually have it electronically. So you have it on your computer. It's one password to unlock, but then that particular program or that document can contain all of your passwords. So for clients of mine who are more tech savvy and maybe even have cryptocurrency and Bitcoin, if you know nothing else about Bitcoin, most people know that you need a very particular code to access it, or it might be forever lost. A lot of those clients do explore what we call digital lockers or digital kind of safeguards to keep it somewhere. But the thing is, again, you got to tell the people you want to access it where it is and maybe how to access that. So keep it current, keep it in a secure location. And again, if you're tech savvy, maybe explore a tech savvy option. If you're not, write it in paper, but just make sure it's somewhere obviously super secure, because we wouldn't want someone getting it if you are broken into, for example.
Thank you. There is a couple of questions about executors. One is, can a beneficiary be the executor? And as well, I hear a lot of times that there are people who really don't have somebody that they can rely on to be an executor. And who could they ask to do that? You referenced a little bit about corporations, but could you expand on that?
Absolutely, yeah. So the first question, can a beneficiary be the executor? Yes. So for example, quite common for husband and wife to do what we call mirror wills. So many couples, especially if it's a first marriage and they intend to benefit each other, and then if they're both gone, they want it to go down to children, which is still a very common situation that arises in my practice. It's very common, for example, for husband and wife to not only name each other as primary beneficiary end of the will, but also to name each other as executor. Alternatively, maybe if someone, it isn't going to a spouse, but it's going down to the 3 children, and you want to name one or more of the children as beneficiaries, absolutely. So yes, a beneficiary can be executor. I think the thing to be mindful of is dynamics, right? Family dynamics. And I know I'm certainly live to the fact that it can sometimes cause tension if you have 2 or 3 children and you pick just one of them to be the executor. Is that going to cause some tension? So again, that's something to really explore with your lawyer. But sometimes it's not appropriate to name all of your children. Again, if one of your children lives in the US, or let's say even if one of your children lives in Vancouver and it's just not practical to name them, because an executor, again, may have to come out to Kingston, clear out your home, there's a physical component to the job, right? So I think you got to think about family dynamics, other things, but brief answer is yes, a beneficiary can be executor. One consideration that often leads to is executors can get paid, right? Because they're doing a bunch of work that typically the beneficiaries aren't. Beneficiaries are just receiving money. It's the executor who's actually kind of winding up your assets, paying your taxes, and distributing everything. So executors typically can earn up to 5% of the value of an estate, and that's usually total. So if there's multiple executors, they would share that. It's not 5% each. There's some complexities that go into that. So that's not a firm number. But it's not half the estate. So I think that's what concerns a lot of people is, gee, I've got 3 kids. I really want it to go, a third, a third, a third. But if I name just one of them as executor, are they going to get more? Well, they might. But in some ways, they've earned that little bit more because they're doing a bunch of work that their, brother and sister didn't do. So yeah, so you can name beneficiaries as executors, but you just kind of consider how will that play out, family dynamics, all the rest. If you don't have anyone appropriate, think a little bit more broadly. So, I mean, do you, for example, have a friend who might be able to do it? Do you have a brother or a brother-in-law, a sister or a sister-in-law? So you may, if you think a little more critically, and I think we're kind of naturally, we think like, oh, my spouse, my children, we think immediate family, but there may be someone like a cousin, you may have a cousin who's an accountant and is an absolute whiz with taxes and very trustworthy. And, so I would say think outside the box. Is there anyone, not just in your immediate family, but maybe in your greater family, who lives somewhat close by, who's trustworthy and responsible? That should be your key question. I mean, if you have any concerns about someone's ability to do this, are they going to find it overwhelming? A lot of people ask, well, do I need to name a lawyer and accountant? No. I mean, at the end of the day, as long as you name someone who's trustworthy, that person can always hire professionals. So if you name your children, even if your children aren't, lawyers and accountants, as long as they're trustworthy, they can hire lawyers and accountants to help them. So I would say the trustworthiness is really the key component. Residency in Canada, within that, even better, residency in Ontario, not just Canada. Those are all kind of qualifying factors. If they have experience doing an estate and they're willing to do it again, great, because typically it does get a little bit easier each time you do it. But if you really don't have anyone, some lawyers are willing to act as executors. So that is usually kind of within our professional option. So sometimes you may be able to name your lawyer as your executor. Some lawyers are willing to do that. Another option is a trust company. So a trust company is a licensed and regulated corporation. And they are basically professional executors, professional attorneys for property. So very important to note is they're generally not willing to do power of attorney for personal care matters, but they are willing to manage your money. There is now a trust company affiliated with each of the major banks. So for example, if you bank with RBC, there's Royal Trust. If you bank with TD, there's Canada Trust. So all of the big five banks do have an affiliated trust company. So if you do, if you do bank with one of the big five banks, usually they're very pleased to kind of introduce you to someone in their trust company department. There are also some private trust companies, or I'll say more independent trust companies as well. So that can be a great option. So because a trust company is a corporation, it's not a physical, a living person, they're going to outlive everyone. Right? So they're going to be around in 100 years. So if you do, I really love trust companies for long-term trusts. So I have a lot of people, for example, who are planning for disabled beneficiaries. And we know this might be a 30, 40, 50-year trust, depending on the age of the disabled beneficiary. That's a huge ask for a family member. So it's one thing to say, hey, can you wind up my estate in a year or two? It's another thing to say, hey, can you manage money for my son for the next 50 years? So trust companies are a good option to consider, because again, they're going to outlive everyone. They'll be around. They're licensed, they're regulated, they're professionals. They can often be a good consideration. So again, if you don't have anyone, again, no one appropriate in the family, maybe you're an immigrant to Canada and you just don't have any family members who are here or close friends who you'd be comfortable asking to do this, definitely discuss with your lawyer if a trust company could be a good option.
Great, thank you. I'm just going to do one more question. I noticed we're almost at time. There was a question about being able to afford, the cost of a will. If you don't have one and you're lower income, you may be concerned about not having a will, but also the cost. Is there a way for somebody to write their own will?
There are. Yes. So yes, there are will kits. There's increasingly options online. Some of you may have heard of, Willful and some other programs. So there are increasingly options online. Don't forget too that Walmart, has kind of simple wills as well, access law. So there are more cost-effective options. I will just mention that we're actually quite lucky in Kingston because we have the Queen's Elder Law Clinic. So that's something that's really neat and specific to the Kingston area is if you do actually qualify for legal aid, there is a special clinic. It's the Queen's Elder Law Clinic, and they will actually do wills and powers of attorney for low income, especially seniors. So that's another option to consider. And again, the benefit is it's under the supervision of a lawyer. So you're actually getting a lawyer reviewed will and POAs rather than just trying to kind of go through this yourself. I would caution, I think it is one of those things, you may not see the benefit of a lawyer drafted will and POAs, but I can tell you your beneficiaries often will. The trouble with people kind of doing wills and powers of attorney themselves is we sometimes find they're not executed correctly. Ontario used to be very, very strict about not permitting validly executed wills and POAs to be upheld. We're getting a little bit more flexible, but if you've forgotten something really important, again, it is its own language, right? Like it is kind of an unusual document, and words we use like residue and executor and per stirpes and everything, like they're not, or issue, like these aren't usual words that people use in casual conversation. So I it's one of those things. I think you may not see the benefit during your lifetime, but a well drafted will and POAs really does pay off when you pass away, because everything that needs to be in there is included in there. Your executor has all the authority they need to do what they need to do. So I would encourage you to kind of go to a lawyer if you can. The thing I'll leave you with, though, is there are actually free powers of attorney available on the Ministry of the Attorney General website. So again, if cost is an issue, there are free, if you just look up Ministry of Attorney General Power of Attorney Kit, there are some free, very basic, very simple POAs on that website. There are some will kits and other options, but it is one of those things it's worth speaking with a lawyer, for sure.
That's great. Thank you, Alexandra, for taking the time to join us today and providing our guests with valuable information on what they should consider when creating or updating their estate plans. You'll be receiving an email with a link to the video and a short survey. I encourage you to fill out the survey as it'll help us plan future webinars and events. Our next webinar will be on February 19th at 1:30 p.m. Speakers Jane Lapointe and Emma Fitzgerald from Asante Financial will discuss working with your financial advisor to gift with intention, and registration from this webinar is now available on UHKF's website. If you're interested in learning more about how you can support healthcare through your will, please contact me at UHKF and I'll be happy to speak with you. Thank you everyone for joining us and have a great day.